Welcome to Employment Law This Week. I'm George Whipple with Epstein Becker Green. Our top story this week, the European Court of Justice rejects the US-EU Safe Harbor program. The case was brought by an Austrian Facebook user who raised concerns about the transfer of his data to the US due to the NSA's PRISM program. The court ruled that the 15-year-old Safe Harbor rule does not adequately protect the privacy rights of EU citizens. The case will have a big impact on companies who are relying on Safe Harbor certification, including U.S. companies who transfer EU customer or employee information to the states. The Department of Commerce is working with the EU to develop new Safe Harbor programs. But there is no grace period for compliance, so affected companies need to find alternative methods now. We asked Patricia Wagner what steps companies can take to remain compliant.
First and foremost, of course, would always be to ensure that the data is as secure as it can be. If you have adequate safeguards and controls, it will go a long way. There are binding corporate rules that can be implemented, which would essentially demonstrate that you're serious about protecting the data and implementing those protections to the data. And there are model contract clauses that can be put into place. But again, those are not a safe harbor. Those are not a shield necessarily, because they could be open to the same scrutiny that the safe harbor was open to.
Data protection is an area of concern for all businesses. October is National Cybersecurity Awareness Month, a great time to make sure employees are aware of the risks and the measures they can take to prevent an attack. The Supreme Court clears the way for the Department of Labor's home care worker wage rule. The High Court recently denied a stay of the D.C. Circuit's decision, so the new rule extending the Fair Labor Standards Act protection to most home care workers will go into effect November 12th. While the department will not begin full enforcement until January 1st, the new regulation will be immediately enforceable by private individuals and attorneys. Mandatory arbitration agreements under legislative pressure in California. Governor Jerry Brown recently vetoed a bill prohibiting mandatory employment arbitration agreements, but further legislative action is likely to follow. Meanwhile, the Ninth Circuit has affirmed the state rule that claims under the California Private Attorneys General Act are not subject to arbitration. We're already seeing the impact of that decision in an ex-employee suit against Estee Lauder-owned Aveda. While California is on the front lines of these efforts, mandatory employee arbitration is coming under scrutiny throughout the country. Consult with counsel to ensure that your agreements meet the standards in your state. On-call shifts challenged in the courts. Both BCBG and Forever 21 have been hit with class action wage theft suits over on-call scheduling. Many retailers are ending the practice, including Urban Outfitters, who cited possible violations of New York's requirement to pay hourly staff for at least 4 hours when they report for work. We'll be monitoring this issue as the cases progress through the courts. And that brings us to our tip of the week. Here to tell us about putting the right infrastructure in place for whistleblowers is in-house counsel Benjamin Baer.
If you're trying to build an effective whistleblowing program, one important tip to keep in mind is not just publicizing the hotline, but it's training managers about when to recognize a whistleblowing claim. Not everything is going to come through the hotline. Sometimes an employee comes to a manager and merely says, "Hey, I've got a concern. I want to talk to you in confidence about that." When they hear those two things, concern, confidence, you should be thinking whistleblowing, and you should give a call to your in-house legal and compliance department or maybe to outside counsel and get some advice on how to proceed. It's the best way to avoid a potential retaliation claim and to make sure that you investigate the claim thoroughly and resolve matters as expeditiously and in the best way possible for everyone involved.
Thanks, Benjamin. And keep an eye out for the Supreme Court's decision on the Neo at Ogilvy whistleblower case. The circuit courts were split on whether the defendant, who did not file a claim with the SEC until after his termination, is entitled to the anti-retaliation provisions of the Dodd-Frank Act. That's it for This Week in Employment Law. Thanks for watching. We'll see you next time.